Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. I recently caught up with the folks at e-Immigration who shared a big announcement. Hot off the presses. Have you heard? E-Immigration is now integrated with the VisaLaw.ai. Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. It's that time of year again, the week before the AILA National Conference. By the time many of you listen to this, you will be at that conference. Come find me. I'll be the guy in the shirt. Got another interview lined up with the current and soon-to-be AILA presidents, and I've got a pretty cool special episode interview in edit as we speak. As I speak, at least. Can't wait to see many of you in person. A bit of news this week, like all circuits before it, the 11th Circuit rejected a challenge that the illegal reentry statute at 8 USC section 1326 was passed into law with the unconstitutional purpose of discriminating against Mexicans and other Latin American immigrants. And also this week, a district court judge ordered Mahmoud Khalil released from prison, I believe, but as of the time of this recording, DHS is refusing to do it. Can't wait for this, our next constitutional crisis. 6 cases this week. Standard stuff. Some good, some bad, some ugly, and 1 case about removing Clint Eastwood. Listen to the end to hear that one. Kicking it off with 2 from the 9th Circuit. First, Lee v. Bondi, published by the 9th on June 10th, 2025. This case is about ineffective assistance of counsel. Judge Collins dissented. And the case regards an issue that literally, the day before I read this decision, I told a prospective client that I couldn't help them with because I didn't think that a claim exists. I have already followed up with that client to say that, you know what? You might have a claim in the 9th Circuit. Mr. Lee is from China, came to the United States on a B-1 visa in 1997, and was paroled into the United States in 1998, indefinitely, somehow. But in 1999, 2 Chinese individuals were detained by CBP, or former INS, near San Ysidro, California, and told the government officers that Mr. Lee had given them false immigration papers in Mexico to get into the United States. 3 days later, former INS NTA'd Mr. Lee, bringing alien smuggling inadmissibility allegations. He denied them. Then he filed a motion to terminate, after the 2 Chinese individuals apparently recanted their statements. Quote, the IJ held an evidentiary hearing over several days in which she took evidence and testimony from Mr. Lee and 3 INS agents present at the September 1999 border crossing. End quote. Wow. And then the IJ ruled against Mr. Lee. Apparently Mr. Lee didn't claim a fear, so he was ordered removed to China, and he appealed to the BIA, where he did not succeed. Then Mr. Lee petitioned for review to the Ninth Circuit, but his attorney failed to file an opening brief, so the Ninth Circuit dismissed that petition for review many years ago. Fast forward 12 years. Mr. Lee is still here, and he filed an application to become a lawful permanent resident. On what basis, I do not know. But USCIS said he couldn't do it because he is subject to an old removal order that hasn't been executed. So, through new counsel, he tried to get the BIA to rescind and reissue its decision from 15 years ago. Surely so he could then try to petition for review again and this time file an opening brief? What a move. But the BIA denied. Despite, it seems, Mr. Lee's attorneys complying enough with matter of Lozada at the Ninth Circuit's level of requirement for compliance to bring in effective assistance of counsel type claims in the Ninth. The BIA denied that motion. This despite under matter of compien from the Attorney General in 2009 that the BIA has discretion to, quote, consider claims of ineffective assistance of counsel based on conduct of the counsel that occurred after a final order of removal has been entered, end quote. Still no dice here, though. Not only did the BIA not see diligence in Mr. Lee's conduct over nearly a decade and a half, but it saw what happened at the Ninth Circuit, that is, not filing an opening brief, as completely separate from its obligations to remedy ineffective assistance of counsel. So, denied. It's not issuing its decision again. A split Ninth Circuit remanded. Reviewing the matter as a motion to reopen, which the Ninth Circuit describes as, quote, an important safeguard, end quote, in the immigration world. Quoting the Supreme Court on that, by the way. Circuits can review this, so long as, like here, it's a statutory motion to reopen where, I suppose, the non-citizen is requesting equitable tolling of the filing deadline. It's still a statutory motion to reopen rather than mere sua sponte discretionary motion to reopen, meaning that circuits can review denial of it by the BIA. And whoa, quote, even if Mr. Lee's motion had instead been a request for the board to exercise its sua sponte authority to reopen, we would still have jurisdiction to review it, end quote. Take note, everyone. But of course, that's review only, quote, for the limited purpose of determining whether the board based its decision on legal or constitutional error, end quote. Still something. And again, here we have a statutory motion to reopen. Now, Oil argued that matter of compien provides the BIA complete discretion to grant or deny motions like this, so effectively, the Ninth Circuit can't review denial of it. We disagree, said the Ninth Circuit. The agency can't just issue a regulation or a decision making something super discretionary so as to, quote, shelter, end quote, the decision from federal court review. That's the Supreme Court's Kukana decision. If the statute divests from federal review, that's one thing. But the agency can't itself make efforts to insulate itself from circuit review. Which, of course, makes complete sense. Rather, the appellate review here is abuse of discretion, like with any motion to reopen denial. Moving on to the merits then, quote, while the board is not required to exercise its discretion to grant Mr. Lee's motion to reopen based on ineffective assistance of counsel, it must provide a reasoned explanation for declining to do so, end quote. Emphasis by the court. Can't just say, it happened at the Ninth Circuit, not our problem, as the Ninth Circuit believes the BIA did here. All of this is supported by Ninth Circuit precedent, and indeed, matter of compien itself explains the divided court going through its own precedent. Flat out, the BIA's, quote, power to consider claims of ineffective assistance of counsel based on conduct of counsel that occurred after a final order of removal has been entered includes the power to review deficient performance that occurs before a different tribunal, end quote. And, quote, that is especially true where, as here, a counsel's alleged deficiencies deprive an immigrant petitioner of any meaningful appellate review of his or her claims, end quote. Seems like an important quote to me. At the end of the day, the BIA didn't explain itself enough, and quite frankly, the Ninth Circuit majority seems suspicious that it can to deny the motion. To me, at least. The majority argues with Judge Collins for quite a bit, including a separation of powers issue, and remanded the matter to the BIA. After all, if there's ineffective assistance of counsel that effectively prevents federal court review, why should it matter where it occurred? Meaning, congratulations Stephen Day McIntyre, Natalie D. Camastra, Sarah E. Higgins, and Caitlin Bosher of O'Melveny and Myers for Mr. Lee. And that is Lee v. Bondi. Next is the Souza, Silva et al. V. Bondi, published by the Ninth Circuit on June 11th, 2025. This case is about religious persecution. Miss de Souza Silva and her family are asylum seekers from Brazil. Quote, she alleges past persecution and a well-founded fear of future persecution on account of her religion, Candomblé, an Afro-Brazilian religion, end quote. And apologies if that's not how you pronounce that, but that's how I'm going to be doing it throughout the decision. I admittingly have never heard of this religion, but I am far from an expert on South American religions. Mr. Souza Silva has been practicing it since she was a young teenager, in secret because her parents were Catholic. She met her husband through worship. It seems she worshipped primarily with the family of her friend Simone, but in 2010, people from the neighborhood broke into Simone's house and murdered her father for practicing Candomblé. Quote, the intruders threatened everyone in the house and told them to move out of the neighborhood, saying that Candomblé practitioners were witches and sorcerers and not welcome in the community, end quote. Simone and the survivors moved away, and Miss Souza Silva never saw them again. The neighbors knew that she and her family were close with Simone's family, and Miss Souza Silva's family became the new main targets in town. Quote, her home was frequently vandalized with slurs and profanities, terms like witch and sorcerers, and statements like, get out of here, and this is not the place for you, graffitied on her walls. At one point, Miss Souza Silva had to take her children out of school because they refused to attend school due to regular bullying and harassment on account of her religion, end quote. Nor could she and her husband really find employment around town, and she thought it was because of her religion. A rock was thrown through her window in 2021 with a note saying that they were wizards, weren't welcome in town, and that, quote, we will not accept you here anymore, people like you, end quote. A month later, Miss de Souza Silva's husband was called out to a farm job far away, but it was a trick. When he went out, a masked man broke into the home with a gun, grabbed Miss de Souza Silva by the neck and put a gun to her head and said, quote, witch, leave this town with your black magic family. This is just a warning. Next time you won't live to see another day, end quote. In Portuguese, I'm sure. He said if they didn't leave, they'd be killed like Simone's father. The couple fled Brazil shortly after that with their youngest child, although they left their two oldest children with Miss de Souza Silva's mother because they couldn't afford to bring them. Unsurprisingly then, in her asylum application in the United States, she said that all of this was making it difficult to practice her religion in Brazil. Indeed, quote, many Candomblé temples are hidden and secret in Brazil, end quote. To the Ninth Circuit, country condition evidence submitted supports this finding. This includes the 2020 Department of State report. Lots of helpful information about this religion in that report, actually, it seems. But the immigration judge was not swayed. No past persecution, the IJ reasoned, for a variety of reasons. The BIA agreed. But the Ninth Circuit did not. Yes, of course, quote, persecution is an extreme concept that means something considerably more than discrimination or harassment, end quote. But also persecution doesn't necessarily mean physical harm. It could be, quote, emotional or psychological, end quote. Or it could be economic. And all of it must be considered cumulatively, explains the Ninth Circuit. Not only that, but religion claims are special. Such claims additionally require an analysis of, quote, how substantially the government or other individuals that it was unable or unwilling to control have restrained a petitioner's practice of his or her religion, end quote. Similar rule in the 11th Circuit, by the way, just off the top of my head. And here, that was totally absent in the agency's analysis, explains the court. Ms. de Souza Silva's, quote, ability to practice her religion freely, end quote, was apparently ignored in the past persecution analysis. And that requires a remand. You can't just focus on the physical harm stuff, no matter how enticing it is, during these complex asylum claims. Past Ninth Circuit precedent has made clear this requirement, explains the panel. Huge quote, everyone, quote, religious practice need not be officially outlawed nor completely prevented to be an important consideration in evaluating persecution. To require a petitioner to practice her beliefs in secret is contrary to our basic principles of religious freedom and the protection of religious refugees, end quote. As such, the failure of the agency to tangle with this factor was fatal. Not only should America not require asylum seekers to practice their religions in secret, but, quote, practicing in secret is particularly burdensome for Candomblé practice, as Candomblé practitioners wear traditional garb or adornments and practice through easily identifiable worship music, generally rich in percussion, end quote. And of course, Mr. Souza Silva literally received a death threat specific to her religious practice, as well as other harms. Given that the new regulations from the first Trump administration on internal relocation remain enjoined, thank God for now, that can't be an independent basis to deny Mr. Souza Silva's claim if she suffered past persecution. So a remand was ordered. Meaning, congratulations Jose F. Vergara for petitioners. And that is De Souza Silva et al. V. Bondi. Next up, matter of EYFG, published by the BIA. It wouldn't be an episode of Immigration Review Podcast these days without a decision from the BIA. This seems to me a cruel decision to make precedential. It's about bond. With that caveat, I'll do the decision without comment, but as a human being, it is difficult for me to understand the executive and certain members of Congress's obsession with incarcerating human beings, along with the spat of recent BIA decisions making it much harder for them to be released. It's a short decision. It's another one that the Attorney General has identified as one that she believes should bind immigration judges nationwide, and so, like with many other recent decisions, it has been designated, even though it was previously unpublished and previously not precedential. Miss EYFG is or was detained. She won withholding of removal. An immigration judge granted her application. She won the difficult-to-obtain relief. DHS appealed, as is its right. It appears that no one believes that Miss EYFG is a danger to the community. Despite having won withholding of removal, however, DHS decided to keep Miss EYFG detained, so she requested a bond hearing. An IJ granted her bond in the not insignificant amount of $10,000. DHS appealed that, as is its right. And the BIA sustained DHS's appeal. It disagrees with the IJ's grant of bond. The BIA believes that Ms. EYFG has not met her burden to establish that she is not a flight risk. I will now violate my no comment from before to again note that the statute does not allocate bond burdens, and that I fail to see a persuasive rationale for the rules giving non-citizens the burden as compared to criminal defendants who do not have the burden in criminal court. I believe the rationale in all other contexts is that when the government decides to take away a human being's liberty, the government should be required to prove that doing so is justified. I believe it undeniable that non-citizens are also human beings who suffer when they are incarcerated. But, retaining the burden, the BIA held that Miss EYFG didn't meet it. Case law lists many factors for IJs to consider when determining flight risk, although, as always, I believe it's a totality-type analysis. Here, the BIA honed in on the fact that Miss EYFG is a relatively recent arrival and does not have a work history in America. Although far more importantly, I can only imagine she was arrested for petty theft in October 2023, had her ankle monitor removed, and then, quote, assisted her son in fleeing from law enforcement after shooting a police officer, end quote. So yes, certainly a pretty unique fact pattern that I'm sure will not be present with most withholding of removal recipients requesting bond. Given this, the BIA believes Ms. EYFG is a flight risk, particularly because the grant of withholding of removal isn't final, as it has been appealed and is not yet ruled upon by the BIA. Short case. They all have been of late, those designated by the Attorney General. One observation. She's got a petty theft arrest from 2023, right? So if the Laken Riley Act applies retroactively to conduct that occurred before its passage in early 2025, wouldn't Ms. EYFG be subject to mandatory detention, making this entire analysis moot? She certainly would if she was an EWI or a 212A7. So if that's the case, Might the Attorney General's decision to publish this specific decision provide support for the argument that even the Attorney General recognizes that the Laken Riley Act is not retroactive? And that is a matter of EYFG. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Upon your return, we have Gray v. USCIS, published by the Fourth Circuit on June 10th, 2025. This case is about naturalization and delay and FOIA, all wrapped up into one pie. Mr. Gray is a longtime LPR from Jamaica. He sat for his naturalization interview on September 2017. USCIS is supposed to then make a decision within 120 days of that, I believe, but they did not do so. Part of the reason appears to be USCIS suspected him of fraud following a home visit that occurred many months later. So Mr. Gray filed suit for the federal court to declare him a U.S. citizen, as is his statutory right, where he also sought FOIA documents and an order compelling USCIS to respond to his document request under the Administrative Procedures Act. But of course, it's not just naturalization applicants who can possibly get discovery during a naturalization lawsuit. USCIS can too. And during their deposition of Mr. Gray, some more details came out apparently about a misprison of a felony criminal charge that he had from 2016. Long story short, it appears that Mr. Gray's testimony about his presence at a shooting at work differed from what he told police at or around the time during his second interview with police at the time. Seems like he might have had more knowledge of the shooter than what he told USCIS. And of course from what he told police the first time. His second interview with police brought forth more details, and, quote, when the police asked Mr. Gray why he was not honest from the start, Mr. Gray admitted that he had been scared, end quote. Plus, there were marriage fraud suspicions. USCIS tried to redact discovery on that heavily, but they messed up and disclosed 305 pages that they meant to redact without noticing that they had mistakenly provided the pages. The parties moved for cross-summary judgment and, quote, each party's motion caught the other by surprise, end quote. USCIS because they didn't realize that they had provided the unredacted documents, now forming a basis for Mr. Gray's motion in part, and Mr. Gray because USCIS was relying on a police report and interviews undisclosed during discovery. What a mess. USCIS ended up winning everything in district court, despite the district court agreeing that USCIS violated Federal Rule of Civil Procedure 26 in withholding the police report and recordings. And boy, can I personally sympathize with this. But anyway, putting aside the FOIA stuff, the district court did believe Mr. Gray could establish his good moral character, relying heavily on the alleged false testimony about his knowledge of the shooting during deposition, and that discovery violative police report and recording. The Fourth Circuit affirmed the district court's grant of summary judgment for USCIS. The Fourth Circuit addressed the FOIA dispute first, which I admit bores me to no end, and which I never do on the podcast despite the proliferation of FOIA lawsuits. To summarize, the Fourth Circuit agreed that USCIS properly withheld USCIS's marriage fraud detection training materials, policies, and examples. Among other reasons, FOIA exemption 7E, quote, protects information that would disclose law enforcement techniques and procedures without requiring the government to show that disclosure can reasonably be expected to risk circumvention of the law, end quote. Riveting stuff, no? Turning then to Mr. Gray's naturalization eligibility and good moral character, something that a naturalization applicant must of course have to naturalize. First, Mr. Gray challenged the district court's refusal to exclude the 2016 police records, which were totally a discovery violation. But, quote, Federal Rule of Civil Procedure 37 gave the district court discretion to sanction USCIS's delayed disclosure by reopening discovery and shifting fees, instead of excluding the belatedly disclosed evidence, end quote. Which is what the district court did here in lieu of exclusion. Not unimportant to the federal courts either, quote, USCIS's delay was at least partly explained by Mr. Gray's unexpected dishonesty during his deposition, end quote. On to the meat, then, of that naturalization denial, 2016 police report admitted and all. Well, giving false testimony to obtain an immigration benefit during the required good moral character period is a statutory bar to naturalization. End quote. False testimony need not be material to the immigration benefits determination to be disqualifying, end quote. Tough burdens naturalization applicants face. Failed here. For example, Mr. Gray, quote, represented that he wasn't there when the victim was shot and that the only possible reason the shooter would say otherwise was because he was seeking a lesser charge, end quote. But in that second police interview in 2016, it looks like he said very different things. Quote, undeniably false statements, end quote, explained the Fourth Circuit. The false statements, of course, must also be made to obtain an immigration benefit, but of course it was here, explained the court, given that, quote, the entire point of Mr. Gray's lawsuit was to obtain naturalization, an immigration benefit, end quote. Still might have survived, though, if he could have provided the courts a more persuasive motive for his false deposition testimony, implies the Fourth Circuit. But it was not to be. Mr. Gray lost his naturalization case. But don't feel too down about it, Mr. Gray. You're probably not removable, and you can apply again 5 years post-deposition. Good luck on your next depo. And that is Gray v. USCIS. Moving on to Antonio de Paz-Peraza v. Bondi, published by the Seventh Circuit on June 9, 2025. This case is about asylum and MS-13. Heard of them? Not really a big deal these days. Mr. de Paz-Peraza is scared of that gang. Indeed, it is such a scary gang that the US government has labeled it terrorist. I want to say that at one point Mr. Trump may have accused Nancy Pelosi of being in it or something. It does get difficult to keep up. At 17 years old, members of this recently designated terrorist group threatened Mr. de Paz-Peraza, demanding that he join it, or it seems that they'd kill him and his entire family. Quote, when Mr. de Paz-Peraza spoke to his friend, a police officer, about the threats, the officer urged him to leave the country, end quote. Gang members threatened him in person with a gun. They stole his stuff. Somehow a gunfight broke out the final time where a gang member and the cop friend were shot. So that's pretty serious. Mr. de Paz-Peraza testified in immigration court that he didn't report this, based on the belief that local police were corrupt. And I mean, I don't know. There was literally a cop involved. Need it really be reported? There's an interesting fact pattern for this whole need to report harm line of cases that's been developing over the years. Where the cop is literally shot, is the shooting itself not sufficiently reported? Someone write the law review article. Anyway, MS-13 also killed 2 of his friends who refused to join, and his brother, who still lives in El Salvador, has received threatening text messages. Mr. de Paz-Peraza did too, even after his last encounter with the terrorist gang. Since he left El Salvador, quote, gang members have asked about him twice, once shortly after his departure and again about 2 years later, end quote. Seems like a pretty legitimate claim to me, notwithstanding, thank God, Mr. de Paz-Peraza not being physically harmed too bad. And IJ and the BIA denied. Because after all, you gotta fear death and terrorists and taxes for the right reasons to get asylum in America. Gotta be on account of one of the 5 protected grounds. Here, Mr. de Paz-Peraza asserted 3 potential particular social groups as the basis. Young male Salvadorans threatened by gang violence, male Salvadorans threatened with death by MS-13, and young male Salvadorans. The agency didn't believe any of these actual particular social groups, nor did the agency see a political opinion claim. And in any event, even assuming a protected ground, the agency didn't believe that these were the reasons. Rather, just a gang doing gang stuff. The only thing brought to the Seventh Circuit was the claim based on Mr. de Paz-Peraza being a young male Salvadoran. And well, the Seventh Circuit affirmed the agency. Not for nothing, though, quote, for purposes of this petition, the government has assumed that young male Salvadorans qualifies as a cognizable social group and challenges only nexus, end quote. I mean, I suppose not binding for future cases, but I wonder if something can be done with that. To the Seventh Circuit, though, even with a valid particular social group, that wasn't the on account of reason. No nexus. The panel believes that, quote, courts regularly decline to find nexus where the persecutors aim to recruit or retaliate for refusal to join their criminal enterprise, end quote. So too here to the court. The evidence shows that the gang wanted to recruit him so they could make money. That his friends were killed and that the gang probably only targets young men doesn't change this conclusion to the court. Quote, however possible or legitimate Mr. de Paz-Peraza's position, it is not so compelling that no reasonable fact finder could disagree, end quote. Relying on standards of review, huh? So, appearing to sympathize with Mr. de Paz-Peraza, the court denied his petition for review. And that is de Paz-Peraza v. Bondi. Concluding then with Tualambo Yanez v. Bondi, published by the Second Circuit on June 13th, 2025. This case is about hardship. Ms. Tualambo Yanez is from Ecuador and has lived in the United States since 1999. She has 3 U.S. citizen children. 2 are currently under 21. She applied for asylum in 2015, which USCIS denied or referred to immigration court because DHS put her in removal proceedings. In those proceedings, she applied for non-LPR cancellation of removal, something you can only apply for in removal proceedings. She seems to have met all the requirements, but as often occurs, the dispute came down to whether she could show exceptional and extremely unusual hardship to at least one of her U.S. citizen children. Here, the older child, then 17 but not now, suffered from depression, while the youngest had asthma. Still does. The IJ didn't believe either of those things enough and denied. The BIA affirmed, in part because the eldest child aged out during the whole appeal. The oldest child turned 21. Before the Supreme Court's Wilkinson decision, the Second Circuit might not have been able to review any of this, but now it can. It can review whether agreed-upon facts meet the legal definition of exceptional and extremely unusual hardship. It just ultimately agreed with the agency. All of this is only about the youngest child with asthma because that child has not aged out. So it looks like a difficult case to win, and it did not succeed. First, though, the Second Circuit jumped on board the trend of not reviewing mixed questions of law and fact like this using the de novo standard of review, but instead under the agency deferential, clear error standard. Lots of reasons for that are from the logic and reasoning of Wilkinson itself, albeit not expressly stated by the Supreme Court. Boiled down, explains the Second Circuit, this is a fact-intensive mixed question of law and fact, and the actual facts themselves are unreviewable if they're in dispute, which apparently affects the circuit court's standard of review that it employs. No circuit has said otherwise yet to my knowledge, that is, that this is a de novo review. But this does actually split a bit with the circuits that have addressed the issue so far, the Third and the Ninth Circuits. Those courts landed on a substantial evidence review, which is pretty similar to clear error, but is slightly more deferential to the agency, explains the Second Circuit. So a very, very slightly non-citizen-friendly ruling from the Second Circuit. Quote, under the deferential clear error standard of review, a finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed, end quote. But by the way, legal issues that are wrapped up in that are still reviewed de novo, such as, for example, the claim that the BIA impermissibly applied its precedent retroactively, which we'll get to in a sec. First, applying clear error review to the facts here, and the mixed question of law and fact, the court affirmed the agency's no hardship finding. Yes, the asthma and related condition may be serious of the child. And yes, Ecuador doesn't have a perfect healthcare system, reasoned the agency in the Second Circuit. But it's not all exceptional and extremely unusual medical hardship. In fact, the record here apparently didn't actually indicate the severity of the medical condition. And while there may be a lot of crime in Ecuador, the country condition evidence shows that much of it is in Guayaquil. And in any event, Ms. Toalambo Yanez sent her daughter to Ecuador on a visit for 3 weeks a couple of years ago. So not great for the claim. On clear error review, no reversal. Ms. Toalambo Yanez's legal argument, reviewed de novo, was that the BIA impermissibly applied its decision from 2020 in matter of JJG to these removal proceedings that occurred pre-2020. In that decision, JJG, the board noted that a qualifying relative's, quote, serious medical condition, end quote, could support a non-LPR cancellation grant. And in the BIA's affirmance in this decision, the BIA cited that decision and noted this language in a parenthetical. The Second Circuit, though, doesn't think that that was a holding that Ms. Toalambo Yanez needed to meet a standard of serious medical condition. The Second Circuit thinks that the BIA was simply using this citation as perhaps a less than clear way to note a non-LPR cancellation of removal applicants' burden of proof. In any case, it doesn't look like the Second Circuit sees much of a difference between a serious medical condition standard for a qualifying relative and the, quote, very serious health issues, end quote, standard that has applied in the non-LPR cancellation context for over 2 decades. Explains the court. So it affirmed the BIA. And that is Toalambo Yanez v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.